Imagine receiving an unexpected legal document in the mail. It can be a very unsettling experience, especially if you aren't unsure what it means or how quickly you need to act. Understanding the rules around legal notices is crucial, and that includes something as serious as an eviction suit. So, how much time does a tenant get to reply to an eviction suit? The precise time frame actually varies quite a bit, depending significantly on state and local laws. Generally, once a tenant receives a formal eviction summons and complaint, they might have anywhere from 5 days to 30 days to file a formal reply with the court. Now you might wonder why such a range exists. This variation stems from several key factors. First and foremost, each state sets its own specific legal requirements for eviction proceedings. For instance, in some states, non-payment of rent cases often have a much shorter response time, sometimes as little as 5 to 7 days. Other states might grant 10, 14, or even 21 days for different types of lease violations. The specific document received also plays a role. Before a formal eviction suit, a landlord typically issues a preliminary notice, like a pay or quit notice, which gives a tenant time to fix an issue before the court process even begins. However, once the actual court papers, known as the summons and complaint, are served, a new, much stricter clock starts ticking for the tenant to file their official answer with the court. The specific rules for counting these days, including how weekends and holidays are handled, are also determined by local court procedures. So, what should a tenant do when faced with these critical deadlines? The most important first step is to immediately read every word of the eviction summons and complaint. Look for the specific deadline for filing your answer. Do not ignore these documents. It is highly recommended to seek immediate legal counsel from a housing attorney or a local legal aid organization. They can help you understand the charges and prepare a proper defense within the given timeframe. Preparing an answer involves formally responding to each point in the complaint and potentially raising any affirmative defenses you might have. One critical term to understand here is default judgment. If a tenant fails to file their formal answer by the court-mandated deadline, the landlord can often request a default judgment from the court. This means the landlord wins the case automatically, without the tenant ever having their side heard, leading directly to an eviction order. Conversely, some states also distinguish between an unconditional quit notice, which demands the tenant leave without an option to fix the issue, and a cure or quit notice, which allows the tenant a chance to remedy a violation before an eviction suit is even filed. These initial notices have their own timeframes before the court process. Understanding these varied response times is incredibly important for tenants to protect their housing rights, and for landlords to ensure they are following the law meticulously. Being aware of these crucial deadlines and knowing when and how to seek professional guidance can significantly impact the outcome of an eviction process. Timely action and informed decisions are truly your best allies in such challenging situations.